All right. Well, Jakob,
you want to do a real fireside?
Yeah, which is like serious. Like,
right.
Imagine
just is in the way.
It's we're in the mountains. There's a huge fire behind us. Of course, it's beautiful in Denver. So, Fred, do you want to share?
Oh, okay.
Yeah.
Yeah, I control this thing here.
Great. Well, Jakob, thanks so much for inviting me.
Of course.
And Brett. For those of you who don't know, Brett, myself, and Nathan Mutter are a group who work at Holland and Hart, and we have a number of offices, and we met at Salesforce. Yes, long time ago, for sure.
First of all, you're very kind saying that I've invited. You reminded me at the last minute that I forgot that I need to invite you. So that was my bad. So we might have been in a different room. But yeah, we just kind of, it's funny. Get in. Don't worry about it. We got acquired in 2016. And I was like, I'm not going to, realistically, I mean, I love Salesforce, it's great, but I'm not going to spend the rest of my life here. So what do I really want to get done in the next couple of years? Is one of them was, I want to get my immigration sorted out, leveraging the lawyers, get my green card. And the second thing I said is patents. Because, at Crux, we talked about patents. We even filed a few patents. There was a moment there where we used to work with this other patent lawyer that is in Palo Alto, and they connected between us, and I sat down with him, and I'm so excited, we're going to file patents. And it was very dry. And by the end of the conversation, I figured out that basically I'm going to do 99% of the work, and he's going to sign something in the end. And at that point, I was like, I don't know. So anyway, we got into Salesforce. And Salesforce has a process that they actually encourage engineers to file patents. It's a Salesforce tie, so there's a CRM that you go through and flow for a Salesforce product that you go through to apply. And I started going down that, and another click, and some more information, another click, and another click. And then I ended up at one of those leadership Benioff kind of offsite places, and next to me I happened to sit the person who is in charge of all the IP of Salesforce. And I said, look, we have, I don't know, a dozen patents, but and he said, oh, we'll fly the patent lawyers in. So Michael, Brett, and Nathan showed up. We got in a room for 3 hours. I filled the whiteboards with a whole lot of stuff. I thought, let's see how it goes. But I kid you not, out of those 3 hours, we got at least 3 patents. I often joke that these guys understand me better than my engineers most of the time. Like, amazing. And they wrote it. I had to read it a few times. Diagrams were there. And I'm like, I'm hooked. So since then, we filed, I don't know, you can count probably like 2,000, I don't know, whatever. A fair amount of patents across multiple companies.
Yeah.
And it's been it's just to say, not all patent lawyers come, it's not one size fits all. And these guys specifically, I found extremely amenable to how we work in startups. We don't have time to go and spend hours to write documents, go back to the lawyer. It's a different language, it's a different world. Navigating it is very difficult, and these guys are taking all the hard work out of it.
Well, thank you. That's so nice. And thanks to Brad, who really does a fantastic job distilling all of this. So now, how many of you in the room have worked on patents before?
So
wow, this is
I have. So like I said, Max is going to be next in line. We're going to do some stuff there. We haven't worked with Habu yet. I think we should. Catch this plenty. Sam has his name on a couple. And Spectrum has one. I don't think you were there when we filed the first one or the second one. We had several ideas. But yeah. So I think that's the extent.
I think it's great, though. I really appreciate that introduction, because we want to tell you guys a little bit about what intellectual property is today, about the process, but the most important thing is kind of breaking down some preconceptions, which many of your colleagues and friends might have said, doing patents is like I write up a big description, and then the patent attorneys make it so that nobody can understand it and charge me a bunch of money. And we've tried to turn that on its head, which is we really like, part of the fun has been riffing with you and saying, what about this? How about this idea? And trying to kind of go in the same direction, really learn technology, and making it very, very easy of a process for you.
Yeah, and I also find that one and you're probably going to cover it at some point, like what's the reason why to file a patent? So what you get out of it, what's the value? Actually, just surely for me, if nothing else, it's a fantastic form of documentation that gets put out there ultimately. It serves a lot to build trust in the team as well as outside on what you're doing. And it also drives, because, and you'll cover it, but part of what you can patent is things you haven't built yet, because it takes time. It's actually, I've learned a lot through the process. Like, it turns out things you already have out there, you can't patent after some time. So it's almost the opposite way around. Another important thing I've learned, and you're probably going to cover, is why you shouldn't patent certain things. And you guys are very good to tell you, I think this is actually.
We'll touch on all of those things. But the most important thing is feel free to ask questions, and if there's something that is unclear or you want to know, we're happy just to have you jump in and ask away. So should we go?
Yeah.
I'll go sit there.
Oh,
Is that okay?
Oh, no,
you
no,
haven't seen it.
You can sit here for
Okay.
You can go there.
Okay.
Give me a couple more at a time. So I'm not going to let Yaakov go. We got to have our full fireside chat.
Yeah.
We'll go through also the kind of process of obtaining a patent, so that you kind of, there's a certain life cycle and a flow, and we're trying to kind of unpack some of that. We want to talk about the differences between a patent and a trade secret, and then some strategic, thinking that you want to think about when you're, all right, I've got an idea, what should I do with it? So that's the agenda for today. So Yaakov, tell us though just a little bit about maybe the favorite one of your patents. So
The favorite one?
Yeah. What and
I hope my children will say. No, so I think looking back, I think two come to mind. One is the original one at Catch, the velvet one, because it was that kind of a year. We had like the first year there at Catch, we had the privilege, Tom said, go in the shed. We're in intellectual accumulation and intellectual expenditure. And we were in the accumulation phase. So we really got to think hard and big about a bunch of stuff. But I didn't know if we're going to stick, is it whatever. And I remember clearly you were very excited. Like when we were talking about it, you were like, oh, it's big. And that really, and you speak to investors and they tell you your startup is okay, you go like, well, you see thousands a day, then it's meaningful, right? And you believe in patents. And so that was meaningful for me at the time, for us, because, like you stumble into some new area, like, I just smoking my own pot here, but yeah, it was really good. And the second one, I really like the Spectrum, the first one, right? Because it was such a moment where you're like, we can do translation for every language. I wonder how it works. And and I'm glad that actually. And I know for Spectrum it was meaningful. I mean, it was definitely thing out of all the patents across all the companies. See, the one we filed at Salesforce was for a lot of stuff we've done in Crux, but Salesforce doesn't need patents. And Crux was gone. And for Catch, it is meaningful, but at the time we were raising money. I mean, it wasn't that, but at Spectrum, that bet come in a really good time, and I think really helped that company forward. So
That's great. Well, I think that it is a very exciting, that's the idea of innovation and being excited is part of what we do.
It's fun.
And that's what makes our job so fun and we represent a lot of companies like Salesforce, but it's so fun to kind of be in at this stage with you, and we really enjoyed that.
Thank you.
So
Albert Einstein was the only patent person I knew of until I met you guys. But it must be a lot of fun.
Oh, it's a great job.
So, I mean, and I don't know if that fire chart we can pick it up, but I have some questions. Right? How did you?
Shouldn't have let him sit there.
How did you end up with? I mean, did you always knew I'm going to be a lawyer? I'm going to be a patent lawyer. I mean, was that like given?
It was not at all. For me, and Brett can share his story. I was a lawyer, and then I went back to engineering school, and I was going to get a PhD. Really didn't know about the whole patents piece. Through just some good fortune, I started working. I was going to school at the University of Colorado. I started to work at the tech transfer office there as a lawyer, and I couldn't believe that this was a job that they would pay you to do, because it's innovation, technology, advocacy, people smiling when you provide them services.
Yeah.
It's not what lawyers usually do. I mean, people don't really love to hear from lawyers all the time. It's a totally different thing. But just the whole innovation process is really fun. So I was hooked, and it's been a lot of
you started in this. So Holland, where did you start first, and how did you?
I was at another firm. There's lots of big firms. There's a big firm that was called Townsend. It was actually, and they had an office here. And but as you know, law firms change. The things change over time. And so I moved over to Holland Hart, and we've started a group there. And so now we have about 70 practitioners who work for us at that group, and we're one of the largest groups in the country. So it's very exciting.
And patents, you span the full breadth, or is it really technology focused?
You do all patent. It's all patents. That's what I mean. The big thing that's happened in the law recently is just a lot of specialization. So we do patents, and we don't even do a lot of patent litigation. We'll consult on that, but it's 99% obtaining and analyzing patents.
And patents, but would you medical, like drugs and?
We don't do any chem or bio type of things, but it's really electronics and software and some complex medical devices that we do. Brett, tell us about your path into the patent world.
Yeah. So I was, an engineer. I'm not an attorney. But I was an engineer, and during school. Yeah. Well, during
engineer. You can own it up now.
Yeah. So during school, so I was actually a mechanical and aerospace engineer, and I did an internship kind of somewhat in industry and didn't really find that what I was looking for. I did an internship actually at a company that does some Salesforce programming, kind of outside of Salesforce though, and didn't really enjoy that a ton either. And then came across Michael and came across Holland Hart, and something that I really enjoyed was writing. I also, in college, I did a lot of writing and then did all the engineering classes. And so when I found out there was this combination of, I can still be in the engineering world, still be learning about all these really interesting technologies, these, cutting edge innovations, but then it's my job then to turn that into something that's written, that's can really explain it well. I just thought that was super interesting. So I
just earned a lot of friends here. There isn't an engineer that wouldn't like to know somebody who likes to write documents.
Well, yeah, that's what I found out. And yeah, in college, it was always, group projects, and I'd be the one writing the report at the end. So, no, so that's kind of how I found out about it, and have been here now 6 years, and it's been great getting to continue to do this. And it is really fun getting to hear about all these great innovations, especially from, kind of these startups where it's is kind of the core technologies that we're working with is so exciting.
So what's the, I don't know, do something with the fireside chat.
Well, let's do one more and then we'll jump
Okay. So what's the, I'll ask both of them in one question. What's your most exciting patent or most famous patent maybe that you worked on? And then what's the one that went, I don't know how patents go bad, but maybe got contested most or generated most amount of.
Well, I'd say the most exciting, we kind of often think in portfolios, but we basically were the firm, and I was in many of the meetings where Qualcomm is a big client of ours, so we were there when 5G happened and came about, and many of the ideas in that room are now working. And when we were hearing them, we're like, is that even possible? And just to be a part of that process from the beginning, and then to see many of our patents get contested, and there's a big Apple and Qualcomm litigation that we weren't fighting over those, but we were doing a lot of analysis. And they stood up, and Qualcomm has added about $100 billion market cap based on that 5G portfolio. So
amazing,
pretty cool. So that was the.
And how many? Just so people understand, because 5G now we know has been out for a couple of years, and my dad was a communication engineer. I understand the gap between when things are thought and when things are there. How many years ago did they file the patent?
It was 2014, 15.
Yeah.
The key days.
Yeah.
So not that far ahead.
Yeah. And disappointing things. The nice thing about the patent office is there's always something. If you have a good drafter that you can get allowed, patents never really die. Usually they're just abandoned because the claim scope gets too narrow. So there's not a lot of significant challenges about that. It was a very terrifying time when Broadcom was going to acquire Qualcomm, and many of our patents and our work there was in it. But it turned out a different way, and it turned out the right way. So, Brett, what about you? What's your favorite patent?
I don't know. I really like. I like working with kind of the small, some startups. I wrote a patent for actually our internal team that we have a group of programmers that adds a lot of value to our team by automating a lot of processes, and they do a lot of some NLP and things, and wrote a patent for them as well. And so I like when it's, I think you kind of pointed out with Salesforce, where it's for Salesforce, they have this huge portfolio of patents, and that's awesome that we're contributing to that. But it seems it really means a lot more when it's okay. Here's our patent, we have one patent, and so I really have enjoyed whenever we've gotten to do that.
Is there a patent you wish you were part of?
You're doing some really exciting things right now.
Yeah.
We love our clients.
Yeah.
So I'm.
There's nothing. No FOMO.
No, it's pretty exciting. Cool. Well, thank you, Jakob.
Of course. Can I go sit down?
So, just quickly, I'm going to turn it over to Brett in a couple seconds, but just to kind of a lay of the land. Does anybody who knows what a copyright is? Okay. I don't want to pick on Jeremy, but
Thank you.
Tell us what a copyright is.
Copyright is when some creative
when some creative person creates work and basically, I guess in order to use that work, you kind of have to pay them or somehow come to agreement to use their work. And copyright, that's a great summary. You know, copyright is all original, has to be original, and it kind of they think of authorship. So, but it can be, you know, a movie, a picture. It can be, you know, anything written. Software is copyrightable. So it's a big field, but it's really protecting, you know, that author from having their work copied. So that's what copyright is. Trademarks. What are trademarks? Go ahead.
Trademarks, I think, is something that identifiable with your brand, and it's meant to prevent people from confusing other people.
That's the best explanation I've ever heard. Actually, completely 100% right. It's about brands, and the whole purpose of trademark law is to prevent confusion. So, you know, you want to have, if you hear superset, you don't want to go, well, which superset is this? You want to know this name or this logo is associated with this company. It's to prevent consumer confusion. So you can imagine those are you know, big forms of IP, but they're not really going to determine whether the companies that we're talking about today are going to be more or less valuable, big picture. What we're going to really talk about are two other pieces, and I'll just mention them briefly. Trade secrets. What do you think of when you think of trade secrets? What do you need them to be?
Secret.
They need to be secret. Thank you, Jeremy. Well done. So the thing about trade secrets, and Brett's going to get into this, it's like it can be customerless, it can be, you know, any type of software code, but it has to be created and add value and be valuable. So, but the key part is there has to be, it still has to remain secret. So much of the, you know, one of the things that Brett is going to get into, what about things that are going to become publicly known or can be found out? How do you protect those? For those, you need to use patents. And patents and trademarks, as Brett will get into, cover a lot of the same type of material. And the question is, do you want to keep it secret? And it can be much less expensive. So that kind of dictates maybe we want to keep something a trade secret. Or do we think it's going to become public, and are we going to be able to protect that idea? And then we might want to do something in that. So Brett, I'll turn it over to you, because we kind of hit on that first part, but I'll turn it over to you. We'll take it from there.
Yeah, and did you want to go through the?
Well, we
Yeah.
we talked about it a little bit. But
Yeah.
Can I pose a question before you get to the nitty-gritty of the process? I mean, isn't the larger purpose of all this legal framework to encourage innovation? And like the real reason is you have the patent person period, and you want to encourage people to profit off their innovation, but ultimately it's going back to the public good.
It's a bargain for exchange. So the idea of a patent is, you know, the idea was, hey, we're the government. We want to encourage people to make their ideas public. So how do we do that? Well, if you make this idea public, we will grant you a monopoly for about 20 years for this idea. But you have to do a full disclosure on it, and you have to tell people how to make and use this. And so that's what we all include in the patent. But it's really a bargain for exchange. You're exactly right.
So the system is trying to encourage patents.
Well, I think that it does encourage that. That's that public policy. But there's some things, the Google search algorithm or Coca-Cola, where you don't want it to be not that public interest in the same way. You want to kind of keep it secret for longer, and so you want to have an avenue that can still protect that.
I just jumped ahead to this one since we're but you're exactly right. We're going to talk here quickly about, you know, the rights, advantages versus the costs, and it is right, that trade-off, right, of public disclosure, but then you're getting the right to exclude But I guess scope-wise, there's really two types of patents that we work with. Mostly is a utility patent, which would be a process, a machine, or a composition of matter, and that's what we've filed for Yakov and for the companies are different processes, some methods that you guys are using in your inventions. But there's also design patents as well, non-functional ornamental design. You could think of that as like maybe the shape of a car's hood, but sometimes for software, sometimes UIs, there might be some design patents available there. But usually the utility patents are the ones that we focus on and that really add a lot of value because they are patenting a process that you're doing, which really helps kind of exclude other companies from doing that. And again, that gets to the rights advantages of why would you want to file a patent? The big point of getting a patent granted and issued is then you can exclude others from making, using, selling, or importing the patented invention in the jurisdiction that you filed in. So if you got a US patent allowed, then no one else in the US can do any of those things within the US for what you claimed in that patent. The terms, 20 years or 15 for a design patent. Again, these are, if you're making all the maintenance payments for these, then you could have the right to exclude others from that invention for up to 20 years, which can be extremely valuable. And especially for some smaller companies or startups or people who are looking for investments, or maybe, someone's looking at you for, acquisitions, have the business value of having either a patent pending or multiple patents pending, or having a patent, issued for your core technology can be, extremely huge for when other people are looking at you and trying to judge, the value of your company.
And Brian, one thing just I think that is so important, what patents do, there's a lot of misconceptions that patents give you a right to do something. Like, oh, I wrote this patent, and I can therefore do what is described. That's really not what a patent does. It just gives you the right to prevent somebody else from doing what's in that patent. That actually drives a lot of value because bears down based on valuable than the right to do something. So anyway.
Yeah.
I guess I have a question related to that. Because most patents, especially in software industry, seem like they're filed defensively rather than necessarily for what you suggested earlier, to do something. It's easy to do something. It's also easy for some troll to come along and say, "Oh, actually, you're not allowed to do that." Is that a major part of patent?
I think that there are three kind of ways that patents are used. One is defensively. So if you have a trove of patents, you can kind of deter your competitors from suing you because it's kind of the idea of mutually assured destruction. So that's one reason a lot of people file patents is on the defensive side. Another reason is monetization. So I mentioned Qualcomm. Qualcomm files patents and they do them just to license them. That is like, hey, go ahead and we're happy to share this technology, it just costs a fee. So that's a second reason. The third reason people file is offensive. And so think of it like in the medical device space. Sometimes you'll want to cover a patent, and you will want to have those patents so that if anybody copies what you're doing, you can aggressively go after them and kick them out of the space. So kind of three different areas: monetization, defensive, and offensive. Brad, anything that?
No.
So one of the things I hear is that you can file a patent for a process. I don't see many technology companies file patents for their user experience and for the process. So if I take an example, Calendly, now there's a lot of competitors. Could they have filed a patent for the process of sharing a link and then having users choose times based on what's available on your calendar? find a patent on this, and then nobody can use the links in order to schedule like code. And if so, like why not more people do it?
I think that they could have filed a patent on that broad idea. What happens is when you get them, you have to go to the patent office and Brett will kind of go into that.
Yeah, I think a key thing to remember with patents is to get a patent allowed, there has to be something novel and inventive in the claims. So if you're going to file claims on that idea, it would get examined by the patent office. And if they find, other either patents or other technologies out there where someone's already doing, that sort of process, or if they find, company doing part of the process, another one doing another part, it would make sense to combine those. And this predates you filing a patent, then you're not going to be able to get those patent claims allowed. You would, as Michael pointed out, we could amend the claims and kind of go after a more specific portion rather than that broad idea, and kind of hone down into more specifics until we get something that is patentable and novel that we could get allowed. But that's why, someone jumping into the space now can't just say, oh, this is what we're doing. We're going to patent this very general idea, and no one else can do it. Only if there's novelty in that process. Does that make sense?
Didn't Amazon patent the one that took out? Or am I miss?
Had a one-click patent. There was lots of litigation around it, and it was just kind of whittled down over time. But it was kind of the poster child for the patent office being much more aggressive about too broad a claim. And
It was not novel, was that the issue?
I think that they did bring in some art to show that it wasn't novel.
Well, that's the
So when it's whittled down over time, that's when it's litigated.
I mean, what I've learned through the process of what's the right patent, and I haven't had one still litigated against, so I don't know exactly what I'm talking about. But we do get sometimes all sorts of jokers coming around. But the thing with a patent is, if you think about it from the patent office perspective, they need to find a balance between letting innovation happen, but also making enough room for other innovation, right? They're creating these swim lanes. So they need something that is narrow enough that it is easier to defend and be unique, but not as so narrow maybe that, there isn't really any fear there. It's almost the case that, the hardest part for me was to understand how to tone down big ideas into these more palatable, smaller, narrow things that are patentable, and they can claim a narrower kind of field. So I think in the calendar case, how much narrow can you make it, right? Because it's a link and you pick some stuff. So it's very, very difficult, I think, to get it narrow enough. You need enough, like I was saying with Nexus, and you need enough, combinatorics to work for it to make it unique. It's this and that, and this and this and this and here and there. Okay, now chances are it's kind of unique.
We've got like 8 minutes. We probably can go a little bit over, but we should fast forward.
And I think this kind of gets at one of the costs or risks, which is the patentable subject matter limitations. What can you actually get patented? And with AI specifically, one concern is this idea of, is this an abstract idea? This is something that's come up at the patent office recently, especially with a lot of innovations in the AI space recently. And so that's something that we continue to work on and figure out where kind of the patent office is landing on, what is patentable in a process that relies heavily on machine learning or AI.
And what's the concern there specifically, that the math behind it is not novel?
So, math, right? It's like an abstract, you can't, patent math. But so it's trying to figure out, you can't patent an equation or, something like that, or an algorithm.
Yeah,
but if the algorithm's doing something novel, that should be patentable. And so that's kind of where there's a bit of confusion that, the office has been kind of figuring out, I feel like, over the last 5 years. But I think we're at a good place right now with the office where it does seem like they're understanding AI inventions better and are allowing it as allowable subject matter. And the main cost here is the public disclosure, as you point out. You're now telling the public how you're doing something, and the fees associated with it, with paying your attorneys, but paying the office, paying to go through this prosecution, file a patent application. All of those are fees that are associated with filing a patent. Compared to that, a trade secret, first off, the scope's a lot broader. Really anything could be a trade secret that is adding an economic or competitive advantage. So even like if you have a list of customers or clients that you think are interested in your product, and you keep that list secret, that could be a trade secret for you. Obviously, that's something that would not be patentable, but is something something valuable to your company that you're keeping secret. The advantages of trade secrets is that you don't have to publicly disclose this. Actually, you're trying to keep it secret, avoiding publicly disclosing it. And so that means as long as you can keep it secret, you could keep that as a trade secret for indefinitely. You don't have a 20-year term like you would for a patent. There's no registration or examination process, so there's no fees associated with that. You're not paying the office to file a patent. And really, your right is just kind of internal. Like you can stop people from your company giving away your trade secrets, but the cost is, or risk is, other companies, if they find out your trade secret, it's out there then. It's out there to them, and they could use it. Or maybe even more worrying is the susceptibility to reverse engineering, especially for software companies. I feel like that's probably the bigger issue, is that, hey, we kept secret how we're doing this, but they see kind of the inputs in, they see what is output out, they see the UI, they see how things work. And so if you don't patent it, they can kind of just figure out, maybe, they can work on figuring out how can we do this, even without knowing how they did it. And if they figure out a way to do it and you didn't patent your way of doing it that covers or protects against them doing it that way, then they can use what they figured out there.
So, and you can clarify that, that's my understanding here, but one of the ideas is, you want to give yourself some advantage over competitors, right? Like in this whole idea. So the question is, you have some secret, what do you do now? If you keep it a trade secret, then you're betting on, like you said, the fact that they're not going to find out, and that's okay, you run ahead. If you file it in a patent, the idea is okay, then the competitors will know about it. But my understanding is, even when you file it, it's not searchable. Nobody can see it. It takes time before it actually is made public. So even if you file a patent today and you're like, oh wow, should I do it? Because if I do, then all of a sudden everybody's going to know about it. Maybe they'll get some ideas from it, do their own thing. It takes a good 2 years, at least.
It's only 18 months or so.
Yeah.
And you can also do a non-publication request.
Exactly. So I learned, I was worried about it, but I've learned through the process that that is not as eminent as you are concerned. It's not the moment you file something, all of a sudden everybody can search it and find it.
Yeah, and that's, kind of this idea of, trade secrets and patents. One thing you can do is file a patent while it's, kind of going through the process. You can continue to keep it a trade secret until that patent's allowed, and then at that point, you have the allowed patent. Again, you might have to do a non-publication request so that it's not published before it gets allowed. But that's one way you can kind of combine trade secrets and patents to make sure that you have protection for your invention kind of throughout the process.
But once the patent is approved, it becomes
Yes.
It's that public policy, right?
Yep.
As soon as it gets allowed and then it issues, it's publicly available because it's part of that bargain for exchange. So once it issues, you can't use it anymore.
You might be going there, but if not, could you at least touch on what do you need to have done in order to get a patent? I have this idea, can I patent it? Do I need to do some sort of work? And then relatedly, can you just mention or touch on first to file and sort of the implications of that?
Yeah, so to get a patent, I think this kind of goes back to our process here. that we discussed. But what we really do, if you have an idea, you think it should be patented, I guess first off, you have great resources here, Jaco, Jeremy, and us, if you'd like to reach out to us as well, who can give you opinions on, hey, do we think you should patent this, file a patent application for this idea? Do we think maybe it'd be best as a trade secret? We're always willing to answer those questions and help you think through the options and kind of the pros and cons there. But if you decide, or we think it would be a good idea to file a patent application, this is really the patenting process that we have, which, again, to Jaco's point, the whole thing is about taking the burden off you guys, trying to make it as easy for you as possible, because we know you're very busy with actually working on the innovations and building your companies. And so really, we just do a 1-hour disclosure call where we meet with you, we discuss the ideas, we get the information we need to be able to describe this invention. And then we'll prepare a patent application. We'll prepare claims which claim the invention, what we're trying to get covered, that claim and then the actual description, which is a long technical document describing the invention. And then there'll be some figures and things in there. We'll provide that to you for review. And so really, you're not doing any of that writing or drafting there. You're just reviewing and, saying, yep, this is my invention, you've got it. Or, maybe we need to add some other details, or if there's something that needs to be fixed there, we'll make those changes and work with you. And at that point, once it's been approved, we will go ahead and get it filed. And so once you have that filing date, once you file the patent application, you have that filing date. That is kind of the priority for that application. And so, as you were saying, first to file. Once you filed, anything that kind of was filed before that, or anything kind of out to the public before that, would be prior art on that invention. And so that's where the office is looking, hey, was this done before? When they're examining the claims, they'll look kind of before that date. Was this done before? And, we might work, again, this is part of the examination process. We'll work with the patent office to maybe amend the claims to get to the specific bit that is novel and allowable over what was done before that priority date. That process might take a number of years. Right now, it's probably a year and a half before it even gets examined at the patent office. But anything in between that year and a half is not prior art. That is after when we file that patent. And so if that patent is allowed and is granted and issued, if someone's doing what you're claiming in those intervening years, you can use your patent to stop them from doing that.
So can I ask two sort of concrete questions?
Yes.
So I'm starting a company, I have an idea, I'm pretty sure I want to patent it, I'm just not sure when.
Mm-hmm.
Obviously, there's other smart people out there who have similar ideas. Do I need to worry that they're going to beat me? And then the second thing is, you need to file this. And then the second thing is, if I am sort of thinking, well, maybe I'll patent it, maybe I won't, maybe it's just a trade secret, maybe it's not so consequential to the business, but I also have to worry that there's someone out there who's maybe going to do the same thing, who actually thinks it's consequential, and then it's going to go file, and I'm like, oh crap, I didn't file it, and now they did. And
So on the first question, I think so what is enough? How developed does the idea need to be? Is that kind of
well, not so much that, much more like, do I need to worry that if I wait, somebody else might file a patent, which then means I'm, SOL.
So we do have this first process, in which I think you were mentioning. There's a strong presumption that if you are the first to file, that are entitled to the patent. Now, so you can always come back and say, here's all this documentation that shows that I had this idea before then, and that can have some measure of rights. But if the problem is occurring out there, you have to worry, and because you really haven't had any time to document what your idea is, and so you are kind of taking a risk that somebody else isn't going to come along and block certain aspects of your idea that aren't well developed. So I do think that's a concern. The second part of your
So
question.
the second one was more of like, I'm not going to patent it, it's not core, but I'm going to do it, right? Maybe it's a trade secret, maybe it isn't. We're going to do it. Do I then have to worry that, I didn't patent it, somebody else patents it later because it's important to their business or for whatever reason they patented it. I can't patent everything in my business, right? So there's a bunch of stuff that I do that I don't patent. What if someone else patents it? Am I in trouble or what happens?
Yeah, I mean, I think in that case, again, it depends on, is this kind of the core of your business? If someone was to patent something, if it's something that's patentable and they were to patent it and it's the core of your company, then yeah, that would be a huge concern. It's
Even
something
if I'm
that
already doing it. I've been doing it for 5
I think
years.
this is the
Yeah.
point that Michael was kind of mentioning, that if you have documentation of how you were doing it, that you're doing it well, kind of before them, there's things that you can do to make sure that they aren't excluding you from that. So yeah, there's that. But if it's you guys are coming up with the idea around the same time, if it's a problem that just comes up and there's two companies coming up with similar ideas at the same time, it would be really valuable for you to get the patent on that before they.
I would trade off this concept of like core, right? Like
No, so it's a trade-off, right? Like you could either proactive or reactive. Sounds like if you wait, maybe nobody will, but if they do, it's okay. You're gonna be in the right because you have, let's suppose you document it, but it's gonna be more effective to protect yourself from later on than to probably just file it now and not worry about it.
Yeah.
One strategy that some people use is to basically there's a process in the patent office where you can disclose what you're doing and not seek patent protection. That's another option if you I don't really, but you do have to file something, and it's kind of another formal process. So most people just, if you're going through that expense.
After they agree together, it's defensive, right?
Defensive,
Monetize.
offensive. So it's the easiest is just think about a medical device. And if there's a certain design of a medical device, you don't want people copying your exact design, right? So if anybody comes close, you can offensively go after them and keep it away.
How should I think about the difference between offensive and monetize? I'm trying to think of a use case where offensive, but I don't care about money.
Because monetize, you want everybody to use it because you're getting
That's more licensing.
with offensive. Anybody, you want it, you're
Yeah. Yeah, go ahead.
Often I still want to publish in peer review. I'm wondering if we've jeopardized ourselves or if it has protected us in some way. The novelty of publishing in that space is that everyone within your niche has said you're the first one to talk about this.
So this comes back to something you mentioned with Crux, is this idea of, okay, I have already publicly disclosed this. Can I get a patent on it now? And in the US, you do have a 1-year grace period. So if you've publicly disclosed what you're doing but haven't filed a patent, you have 1 year to file a patent on those ideas. No, it's
1 year
more,
from your public
once you've publicly
disclosure,
disclosed,
so like
yes.
an external article is
So if
published.
if you publish this article to the public, to peer review or something,
What if you put it on a special website? Does it should be peer reviewed, right?
no, yeah, and any public disclosure of that's not like under NDA, that's not, that's kind of your priority date at that point, and you would have a year to file a patent application on those ideas. Again, you have somewhat protect yourself because you've now said, hey, this is, we've done it this way. And so if someone, again, comes in the middle of that year, if you file a patent application, you predate them because you publicly disclosed at that point. But if you are beyond that year, then in the US system, you really can't then file a patent application since you publicly disclosed
But the
over a
other
year
ones
before.
wouldn't be able to either, right? No,
Yours would be prior art on them.
your published paper would prevent others from getting a patent on anything. So we often get at the patent office. That prevents us from getting patents.
I mean, the perfect way to do it, file a patent and then publish it.
Yeah.
Because you can do that regardless. This is in the making, and you're gonna get it both.
Yeah, the ideal thing is, get the patent filed, and then, even if it's the day before, and then publish the paper. That's
Remember,
usually the one.
if you publicize it, right, then you might be telling somebody how to do the thing that you're doing that you don't want them to do, which is why you would want the patent. But most of the patents that we get, I think, are more defensive, right? We're not really looking to go out and get people, but what ends up happening is somebody comes to you doing something similar and says, well, we have this patent. Like, great, we've got this patent. This is this mutually assured destruction. We're like, you attack us, we'll attack you, like, let's just call it peace. So, I'm sure when you're publishing, you're thinking about, okay, do we want to tell everyone what we're doing? And like, if you've made the decision to publish, maybe there's things in there that it's fine if people know, but if you're concerned, you
The general research people feed off each other's ideas
right.
and then you build on. So it's a matter of finding that niche that is specific to you that you can protect. The other question that I have related to this is typically when you want to publish, you've already done the work, you've already completed and gotten it all. But it sounds like with a patent, you don't need to do the full work, you just need the idea.
Yeah.
So it's kind of even like in time scale,
That's right.
are very different time scales.
You should patent. My experience knows that you should have patented earlier. There's no, again, with the way these guys are running, like I said, not all patent lawyers are the same. But these guys, they're so good at what they do. They offload so much of your work. The question is, do you have something patentable? They'll help you understand that. But if you do, they shouldn't. I'd love to see a lot more patents, because it's zero regrets.
Yeah, you don't have to prove it works. If this, you have this idea, you know enough that you know how you want to implement it, then we can get a patent on that.
I shouldn't say this too out loud, but it's also not that expensive. Like, so.
It's not the grand scheme of things.
Talk afterwards.
I'm check, the next session starts in 5 minutes, so we should maybe.
Okay, so I read one last question.
Yeah, what are you guys' stance on like more nefarious purposes? Because like, you have something and you never intend to use it. That's hypothetically a medical device, right? Like, I have this medical device can help people with this disease, but I put a patent on the cure of that disease.
So there's a lot of non-practicing entity work out there, and we just don't do that. And that's kind of not. There's nothing wrong with it, but it's just we really and incorporate user technology.
But that does happen, right?
Oh, it happens a lot. Yeah, it's a big deal. It's kind of causing a lot of problems in the innovation community. Sort of. It's just.
We're gonna have to wrap. Any closing?
Yeah, I think the main takeaway really is just, if you are working on something that you think is, innovative, that you think is, important to your company, reach out to us, to Yakov, to Jeremy, and ask, hey, we were thinking we might want to get a patent on this, or hey, maybe this should be kept as a trade secret, and we will work with you, provide our insights, and hopefully get you some protection on your ideas. So.
Great.
Thank you.